Welcome to Military Justice and the Law, presented to you by Bulani Tseu. In the previous episode, I indicated that I'll be talking about the Directorate of Military Prosecutions. I have since abandoned that campaign for now. Instead, I'll be talking about an aspect or an issue that affects all military law practitioners, which is their security of tenure. Security of tenure basically is employment security. And some people have employment up until retirement. Others have employment for life. Others have employment for a fixed contract. The Constitutional Court, in many of its decisions, outlined the importance of adequate security of tenure. It was made clear in Glenister versus the President of the Republic of South Africa and others that security of tenure enables the incumbent, to be able to discharge his or her own duties fearlessly and vigorously. In other words, adequate security of tenure empowers the incumbent to resist pressures that may come from external persons, especially those who wield the power to renew contracts. Within the context of the South African National Defence Force, employment contracts are regulated by the Defence Act 42 of 2002. Accordingly, soldiers may serve until at the age of 65 years. However, the general retirement age is 60 years. Only in exceptional circumstances that soldiers can serve beyond the age of 60. Other soldiers contract therefore a fixed period. Some are contracted for 5 years and others for 10 years. So military law practitioners, just like all other soldiers, fall within those categories of contracts, basically. Accordingly, a military law practitioner who has a contract with the SANDF until retirement enjoys adequate security of tenure. There are also those who are contracted on a short-term or a medium-term basis. In the not-so-distant past, there was clarity regarding what a short-term contract entailed and what a medium-term contract entailed, because, as I've already alluded to, a short-term contract lasted for 5 years and a medium-term contract lasted for 10 years. But in recent times, military law practitioners have been receiving contracts for 2 years or 3 years at a time. So, in my view, a military law practitioner who basically has a short-term contract or a medium-term contract is susceptible to being influenced in a particular way, especially by those people who have powers to renew those contracts, being the military executive. This view is not designed to impugn the integrity of military law practitioners who are on a short-term or a medium-term contract. After all, military law practitioners take an oath, wherein they swear to discharge their duties without fear, favor, or prejudice. But there is literature abound wherein incumbents who had previously taken an oath of office were never stopped by that oath in terms of behaving in an unscrupulous way. So essentially, it must be remembered that without the adequate security of tenure, military law practitioners may find themselves basically, having to do things not in accordance with justice. I'll explain this. For example, prosecutors, they are supposed to basically finalize 60 cases per financial year. Judges, 120 cases. Defense counsel, 70 cases. The problem with this is that in the event a military law practitioner does not meet those prescribed targets, such an issue can have a negative bearing on whether that person is employed further in the South African National Defence Force. So essentially now, That creates a situation where prosecutors may want to rush cases in order for them to make the targets, therefore putting themselves in a good stead with regards to contract renewals. Similarly, with judges as well, if they don't make those targets, they stand basically not to get another contract. So there's a problem. There's a problem with that. And this aspect has a devastating consequence for the accused and for the state as well, because justice must not only be done, it must manifestly be seen to be done. So chances are that the accused person may be sacrificed at the altar of the statistics. Therefore, he or she may not get justice because a functionary may want to make his or her own targets at the expense of the career of the accused. Equally so, the state may be prejudiced by this, in the sense that one may want to rush cases instead of focusing on justice per se. So essentially, justice rushed is justice crushed. So clearly, the fundamental rule of nature is that of self-preservation. A person will want first, to see to it that his own employment is secured. That's logical. At the same time, sacrificing, as I've already mentioned, the interests of the state and those of the accused person. Fear to lose one's employment is, in my view, stronger than justice, because one will want to safeguard his own plate of food. Doesn't really matter what happens to the other person or to the state in that regard. Because once again, if you don't meet these targets, the likely situation is that when you are being assessed, you are not going to qualify, or you may not qualify for a pay progression, which is the 2% that ordinarily the South African National Defence Force members get. So you may not qualify by reason that you did not meet your targets. So essentially, what I want to bring across here is that in the event military law practitioners' security of tenure is not adequate, there is a likelihood that Lady Justice may suffer. So what is it that I'm trying to talk about here is that if one looks at the fact that there are many other military practitioners as we speak who are basically attending courts, high courts, wherein they are fighting to reassert their rights with regards to the employment. And those people, such matters are readily available. One can look at the internet. We really go through those things. We see military practitioners fight against, the employer. So in my view, it would be best if ever the issue of employment contracts of military practitioners can be visited, because absent that, they may find it difficult to execute their task without fear, because the fear will be there to say, if I do not meet these targets, I may end up without employment. So as I've said, although the accused person has got a right to a fair speedy trial, that speedy trial must be done in a fair manner. Equally so, the Constitutional Court in State versus Jaipal informed us the right to fair trial also extends to the state as well. So it will be best if the interests of the state are represented by lawyers who enjoy adequate security of tenure. So in this episode, I've made mention of the fact that there is literature abound that adequate security of tenure empowers the incumbent to be able to discharge his functions fearlessly and with vigor. And the current status with the majority of military law practitioners is that they do not enjoy that particular tenure, the adequacy thereof. And I've made mention of the fact that such a circumstance, because military protection, they want to rush cases in order to meet the targets, therefore sacrificing justice, sacrificing the right of the accused person and the state to fair trial at the altar of meeting these numbers. So also, I've indicated here that there are those military practitioners who are basically contracted until retirement. And I've said those ones enjoy adequate security of tenure. So that is basically all that I wanted to cover today. Going on from here on, going forward, I'll be basically reverting back to discussing the Directorate of Military Prosecutions. So until next time, take care. Don't forget to subscribe.